Hello, everyone. Thank you so much for joining us today. We know you've been busy these past 2 days, and most importantly, you've been working really hard. We hope you're enjoying, and we can't wait to see what you're going to come up with tomorrow during the pitches. But for today, we have a very interesting workshop for you, which talks about the legal aspects of your business and all the things you need to take into consideration when you're starting from a legal perspective. With me is one of the greatest lawyers in the UAE and a legal counsel at many prestigious firms. Please, without further ado, welcome with me Ghassan Haddad. Ghassan, you're on now.
Thank you, Naeem. Thank you for the introduction. Good morning, everyone. Good afternoon. I think it's 4 p.m. Everyone is busy finalizing their pitches. I've been receiving quite a few questions since yesterday in the mentoring sessions, and I thought I would tackle them on a more general way in this legal workshop. The way I'm gonna present it, hopefully it's not gonna be that boring, because when it comes to legal, usually it's a bit boring compared to the product or the idea that you have. So we're gonna go through what I call a legal checklist. So this legal checklist will vary from one law firm to another, from a legal counsel to another. You might have tackled this checklist from another angle, so from your idea or from a finance perspective or from a tax perspective, but then we're gonna take it and we're gonna look at it from a legal perspective. The legal checklist that I have has 6 elements, and we're gonna go one by one, and then we're gonna discuss the legal aspect of them one by one. The first question, I'm sure you're familiar with this question. Everyone is telling you define your why, i.e. your mission. To come up with your mission, you should start with the reflection. Why do you want to start this business? What are you trying to accomplish? What will it mean for your life, for your coworkers, for your customers? How will you create changes within your business? And why this business have to exist now? And why do you have to be the person to start with it? Usually your mission is tackled not from a legal aspect, but why it is included in the legal checklist. It's so important to start with your mission and to define your mission, because it will depend, it will affect the legal entity that you're going to create, the country you're going to incorporate in. It will affect from a customer perspective where your customers will be based. Are you tackling a worldwide customer, or you're going to tackle just customers that exist in a specific country? The agreements that you're going to sign afterwards. So it really all evolves on your idea and where you're going to go with this idea. However, this idea is not set in stone. It can evolve with your business. You can start with being an e-marketplace in the UAE and then change your mission to be a worldwide e-marketplace. And your legal considerations would change. The second, so I'll give you a bit of examples of a mission statement if you didn't already drafted yours yet. Tesla one is to accelerate the world's transition to sustainable energy. LinkedIn to connect the board's professional to make them more productive and successful. PayPal to build the web's most convenient, secure, cost-effective payment solution. And the company I work for, one of the companies I work for, which is Kafu, which is an on-demand fuel delivery digital tech company. It is to bring value to our cities and customers and to take refueling cars more convenient, reliable, and accessible by putting an end to the time wasted at a petrol station or petrol pumps. So from the mission statements, you would know what's the line of activity that they would have. So for instance, in LinkedIn, it's an e-commerce that would connect a platform that would connect professionals together. For PayPal, it's a payment solution. A payment solution will entail, in some countries, a regulated activity. So they would consider before being incorporated, say in the UAE, to get some approvals from the central bank, etc. So their mission is affecting their legal consideration. If we go to the second checklist point, which is define your end goal. Defining your end goal is slightly different from defining your mission statement. It's more specific and it's more concrete. What you need to do is to picture yourself in 1 year, 5 years, 10 years down the line, and at the end of your career. Where do you see your business down the road? Do you want to have outside investors with you? Do you want to be publicly traded on a stock exchange? Do you want to remain small and fit your existing life? Do you want to sell the business and spend the rest of your life on a beach? So it really depends. So your exit, we lawyer always think So when we draft a marriage agreement, if you want, we think about the divorce, because it's so important to prepare your exit, because it will define how you're going to engage in this company. So are you looking at it staying in this company for your lifetime? Are you looking at it from an angle that I would stay for 5, 6, 7 years and then I would move on? And this will impact again and again your legal decisions. So let's say, for example, if you're going to be a publicly traded company on a stock exchange, you would like to be incorporated as of now in a jurisdiction that would allow you flexibility, that if ever you want to go IPO or you're going to be publicly traded, it will offer you the right environment to switch to being a publicly traded company. If you want to remain small and fit your existing life, you might consider maybe a company that doesn't require any minimum capital, that has like a very minimum legal documentations to have, because you are planning to remain a company for your friends and family or for your just city, etc. If you want to sell your business, you want as well to incorporate in a country or in a jurisdiction within this country that would allow you to sell with ease, with maybe digital documentations that wouldn't require all documents to be authenticated, etc. So each and every decision or each and every end goal that you would have would as well have a legal consideration. The third item is define your who. What do we mean by who? We mean by who the people who will be involved within your business. So it's not a legal requirement per se, but it will definitely affect as well your legal decision. The who of your business can be broken down into 3 parts. First, you have your partners or your co-founders. Second, your employees or independent contractors. And the third item is the other collaborators, be it investors, lenders, vendors, or service providers. If we go to the first who, which is the partners, you should identify as of now who is the partner. And it's so important that you and your co-founder have the same end goal. Of course, the same mission, but most importantly, the same end goal. You cannot have an end goal of having your business small and your co-founder wants to go trade on a stock exchange. You cannot be someone who wants to sell the business 2 years down the line and your co-founder wants to remain in the business all his life and want you to remain in the business all your life. If you don't agree with your co-founder as of now on your end goal, you will have a lot of issues down the line. One way of defining your role, your responsibilities between you and your co-founders is usually done in a founders agreement. What is included in a founder agreement? Obviously, the names of the founders, the company name, the ownership structure. So how much shares you would own and how much your co-founder would own shares. And this will really depend. So there is no black and white. It will really depend on the initial capital that was put by you or the co-founder. It will depend on the contributions that can be cash, property, service rendered, promissory note, combination of the above, or a promise of a capital injection that would be done by you or the co-founder. And when you have a contribution that is not linked to cash, you should value it as of now. You need to figure out the monetary value and record it here, because this will depend as well on the percentage of ownership of each one of you. You should always as well consider by ownership structure. So if you own more than 51% of the company, you would likely have the day-to-day operation management responsibilities that you can undertake without your other shareholder. You would have to think about reserved matters. What we call reserved matters are the matters that would require your other co-founder to approve. I'll give you an example. So reserved matters would go, if you want to take an example of your business, you started as a medical device dealing with diabetes, and you want to start a new medical device that would deal with high blood pressure. It's you're shifting your business line, and because you're shifting your business line to another medical device, usually this is considered as a reserved matter that your co-founder would like to have a say in and would like to approve that this company can start looking at high blood pressure medical device and not just only diabetes medical devices. So you would set, as of now as well, the list with your co-founder on the items that are crucial for both of you to decide on jointly, keeping in mind that this can really be as well, can really affect your company life and your decisions, and can delay decisions that the company can take. So what you need to put is a threshold for what the manager can take. So in this case, if you're having 51% of the company and you're the manager of this company, you can take without going back to your co-founder. And what are the matters that are absolutely must to have his approval. Another thing that you would find in the founder agreement is obviously the project. So as we said, the description of the startup business, an overview of where you're heading, etc. The expenses, the budget, and the tax. So this usually is agreed on a later stage, but if you know it as of now, what would be the budget and the expenses, you would include it. The roles and responsibilities of each one of you. And this is really important to define as of now. It's important. Why? Because you need to be aligned on how much time and investment you want to put in this startup. And I have, throughout my experience, I have encountered a lot of problems with founders after 1 or 2 months, because one of the founders started a full-time job, cannot continue anymore with the startup, but the other founder was expecting him to be full on board, to be fully dedicated to the startup. Another reason would be you ran out of money, you ran out of savings, you don't want to continue as well. So it's really important to set in your founder agreement what are your responsibilities and what would happen if someone is in breach of his responsibilities. Is someone who was devoted at the time of incorporation of the company to be 100% focused on this company, and after 6 months or 7 months he decided not to be any more focused, or to have a sideline business, or to be an employee, or to go back to the corporate life, how you would treat him if he wants to exit? Will he lose his shares? Will he lose just his position in the company? If he loses his shares, would you have the right to buy his shares before someone else? All these kind of scenarios should be agreed on even before you incorporate the company. We talked about the management and legal decision making, the operating and the approval rights. Another item, obviously, is the salary and compensation. And again here, so there is no black and white. You can have a salary, a fixed salary. You can have a bonus scheme that's related to the revenues that this company is generating. You can just say, I'm relying on my dividends. So I have 51% of the company. If the company is generating revenues, I will get the 51% to me, and that's it. I don't want to have a fixed salary in the company. One of the items as well to look at is the intellectual property assignment. Usually, when you start your business before you incorporate the company, or before you go into the legal aspect of the company. You start with an idea, you start developing this idea in your house, you start pitching this idea to other people. Everyone would collaborate in order for this idea to take form. So if it's a medical device, you would reach out to suppliers, you would test and see, and then if you see that it's viable or it has a potential, then you would go down the legal cost and everything. So all the work that you have done before incorporating or before reaching out to your co-founder and starting this venture together is intellectual property that you own directly or indirectly. So it's very important that when you start your company, or when you reach out to your co-founder, or when you incorporate the company, to assign whatever intellectual property you have to this company. It's not anymore your ownership, it's the company ownership. And why it's the company ownership, we're going to go afterwards, we're going to talk in depth about the intellectual properties that the company can have. It will really raise the value of the company, and hence the longevity, the continuity of the business, and the expansion of the business. So you cannot, I would really not advise for you to continue owning the intellectual property, but rather to put it in the company to create value at the level of the company that you're creating. The last 2 points is we talked about removal or departure of the founder. So if any member of your company, God forbids, die, become disabled, go bankrupt, is fired, what you're going to do? Are the remaining members should have the right to buy out? If the right of buyout is there, at which price? Do you want to define as of now the price that you're going to buy out his shares, or you're gonna put it at the market value on when this happens. So after 2-3 years, when the company has more value, and then he wants to sell his shares to you and leave the company, so you will buy it at the market value. So it really depends as well on your agreement with your co-founder on this point. Finally, as well, you should agree on the dissolution and termination clauses. So no one likes to think about the end, but it's best for everyone involved if you do. So outline what circumstances or events would lead to dissolution of your company. You're not agreeing anymore with your co-founder, the business is not working, you cannot continue with him. You should specify this in your founder agreement, and you should say that if this kind of event occurs, we're going to dissolve the company. You're not allowed to continue without me, I'm not allowed to continue without you, but the company cannot continue as such. So this is one way of winding up and distribution, and you can agree as well on, you can go further and agree, if we decide to dissolve the company, I'm going to take these assets of the company and you're going to take the other assets of the company. Finally, dispute resolution clause. So by dispute resolution clause, we say, okay, you have a breach or you have a claim under this agreement, someone didn't do his wasn't doing his responsibilities, or breached any kind of arrangement between the co-founders, under which jurisdiction this will be resolved. So you have usually, I mean, as a general, two paths. So you have the path of the courts, and then you have the path of the arbitration. The path of the courts is less costly, but then it can take few months to years to be resolved because of the delay of the hearings, because of the proofs that you would be required to give, etc. So the arbitration route is quicker, but is usually more expensive to go down this route. And usually it's the cost is shared between both parties, and in some arbitration centers, the winning party can claim back the money that he put as a cost of the arbitration. So as well, again, these all what I'm talking to you today is just food for thought in order for you to think about, and then when the moment will come and you incorporate your company to really put them on paper or put them in documents. Never, ever, and this is really, I mean, I can't stress enough, don't rely on trust, don't rely on good faith. This is an arrangement, this is a business relationship with your co-founder. Both of you should be at ease to sign an agreement that will specify your relationship in this venture, how it's going to start and how it's going to end. There is no hard feelings in asking to have a founder agreement in place between you and your founder, even if he's your brother, even if he's your father. I mean, you should think really from a very objective point of view, and you should always ask to have a founder agreement in place. The second who that we talked about in the company is your employees or independent contractors. So it's extremely common for businesses. So when you start your venture and you don't want to incur costs that are related, say, to pension charges, to national security charges that you would pay normally to your employees, you don't want to incur costs related to visas, to sponsorship. So you would not employ in the beginning usually employees under your company visa, but you would rather reach out to people as an independent or as a freelance contributors to your company. This is okay as long as the people you're reaching out to are not de facto an employee. What do I mean by someone who's de facto an employee? Is someone who's working for you full-time. Your business monitors him closely. You monitor the time, you monitor the place, and you monitor the manner of their work. If you do all these kind of monitoring activities, then your employee, even if he's considered, I mean, on paper as an independent contractor, if as well, God forbid, and he goes and claim under the court because you didn't pay him, I don't know, fees for the month, etc., he might recharacterize the contract, and the court would judge that this is an employment contract and not an independent contractor contract. They would impose fines on you. They would impose to pay all the pension funds that you didn't pay so far, and then maybe they would qualify your termination of the contract as an unfair dismissal under labor law, and then they would ask you to pay additional compensation for your independent contractor. So it's really important as well to define who will be your employees and who will be your independent contractors. Not based on the decision of your business, but based on the nature of their work. Things to consider as well under this category is the confidentiality and assignment of IP rights clause, which can be in both the employment contract and the service agreement contract that you have with your independent contractors. What do I mean by confidentiality and assignment of IP rights? Confidentiality, basically, when you employ someone and you give him access to all the books of the company, including the trade secrets, including the customer data, including the way it functions, the tech, the back end, everything related to this company, these are all confidential informations. And you don't want this employee who's going to be maybe for 10 years in your company, or he's going to be just for a month in your company, to go with this information, to send them, to give them to competitors, to use them for himself, and to open an unfair business next to your business. So it's really important to have a confidentiality clause in place in your employment contract or in your service agreement. Another clause that you would like to include is the assignment of IP rights. What do I mean by assignment of IP rights under employment contract and under service agreement? When your employee creates work for you, be it a copyright work, we're gonna tackle the copyrights and the trademarks on later stage, but whether a content, whether he's collaborating in the technology that you're creating, these are all intellectual properties, and you should include in your employment contract or in your service agreement that this employee, whatever work he's doing under this contract, will be assigned to you and will be owned by the company, not by him anymore. You don't want to face issues of employees or of contractors telling you, we have created this work, but it's ours, it's not yours, and you have to pay me an additional fee in order to transfer this IP to you. So it's important to include an assignment of IP rights, as I mentioned earlier, in your employment contract or in service agreement. Another thing to consider under the employees section is the employment stock option plan. Employment stock option plan, I'm sure you heard about it before. So it's basically a plan under which you give your employees some shares in the company. You should have a grant agreement in place. You should have the plan terms and conditions that the employee can have access to. And you should define when they're gonna get shares, how much shares they're gonna get, and in exchange of what. So they should stay in the company for 1 year, 2 years, 3 years. How the shares will be vested? Will you give your employees shares from day one? Will you give them as they evolve or as they become more and more senior in the company? Do you want to give the shares to everyone working in the company, or do you want to give the shares just to the management of the company? So these are all things as well to consider when you tackle an employment stock option plan. As well, I mean, you should either think when you employ employees, if you're gonna give them a fixed salary, or it's gonna be a bonus scheme, or it's gonna be an incentive kind of scheme based on the revenue of the company. This you should define them in your employment contract. If we move to the third who, which is your other collaborators, I'm gonna talk mainly about the lenders and investors. So if you collaborate with people who will be providing you funding for your business, you need to think about what type of relationship you want. At this stage, you may not know specifically who your investors will be, but you can start to think what type of investors you want in your company. Do you want to have an investor who gives you money and gets out of the way? Or do you want someone who will be acting as a mentor for your business, as an advisor for your business with a board of directors seat and hands-on involvement in the day-to-day operations? And it really depends as well the nature of the investor you would be reaching out to. So for instance, the basic investors or the lenders would be the banks. And the banks wouldn't ask to have a board seat, wouldn't ask. They would charge an interest rate for the facility agreement. They would ask for a collateral. So a collateral means a security for the debt you're incurring under the facility agreement. Security will be a personal guarantee on your personal assets, or it will be on assets of the company. And we're gonna as well discuss in few minutes how your IP can be an asset that you can provide for banks in exchange of a facility agreement. Another type of arrangement you would have with your investors at an early stage in your funding path is the simple agreement for future equity, which is the SAFE. Under this agreement, you would agree with your how do you say, early adopters or early investors, that they would give you a bit of money, and then when you start your Series A funding, which is when you reach to like institutional investors, their contribution will be transferred to shares. But until that time, it will be just a contribution or a debt towards the company. This is mainly now, I mean, in trend, if you want, trending in all the UAE, with all the UAE startups. So they prefer to have a safe agreement with low money contributors, if I may. So, and then this equity or this contribution will be transferred to shares once we have an institutional lenders in place. The fourth item on the checklist is define your where. When we say where, you can break it into three parts. Where do you want to work? Where do you want to register your business? Where will your customer be? Let's have a look at each item in more details. First item, where do you want to work? It's so important to define where you're going to work because of the type of legal agreements that you would sign with your service provider. Do you want to have a fixed office? Do you want to have a hot desk? Do you want to sign a lease agreement? Do you want to sign a shared office kind of arrangement? And this will define as well the legal clauses that you would find in the agreements. Because if you obtain a good leasing price, for instance, for your leased premises, the lessor would require a minimum commitment for you. He would be strict on termination clauses. He wouldn't allow you to renegotiate the rent, or he would say that there is an increase of 5% per year per rent. You should also negotiate clauses that are related to force majeure. Like, for instance, when we had the COVID, no one knew that we had no one knew that we would have a lockdown out of a pandemic, and people wouldn't be able to access their premises or their leased premises. One of the clauses that everyone looked at is the force majeure clause. And what is the definition of a force majeure? Does it include pandemics or doesn't include pandemics? If it does include pandemics and epidemics, the party negotiating, the person who's leasing the property, would be in a better shape to negotiate the lease with the lessor and telling him, look, I'm going to suspend the lease agreement. I'm not able to access my premises. I'm going to suspend my obligations. I'm not going to pay you rent until the country that I'm leasing under would allow me to go back to work. People who didn't have this pandemic item had hard time. If the country was not pro businesses, they had hard time renegotiating the lease agreements with the lessors. You also have to think, when we say where do you want to work, about the legal notices. When I say legal notices, it's a section that you would find in quasi every agreement that you would sign with any counterparty, that would specify a physical address under which you would be served notices related to the agreement, lawsuits, claims, and this address usually is your registered address of your company on the trade license. You can specify another notice address, but you have to think about where do you want to have this notice address. Where do you want to register your business? So I'm going to take you through very rapidly the UAE. So the UAE is formed of 7 emirates. You have Abu Dhabi, Dubai, Sharjah, Ajman, Al Quwain, Ras Al Khaimah, Fujairah. They all adhere to federal laws, but then they have each one of them its own laws as well. Additionally to these emirates, you would have free zones that would have as well some particularities and some laws that would apply to a free zone and not apply to the emirate or to the mainland, what we call a mainland. You have a choice of basically registering whatever you want, in mainland, in the free zone. And again, there is no, the only criteria that you would think about when you want to choose which free zone or which emirate you want to register in is the ease of access, the cost, the ease of opening a bank account. Is this free zone will help you to open your bank account? Does it have good relation with banks? The access to phone and ownership. Usually free zones allow 100% ownerships, but in mainland it depends on your trading activity, and then you might require to have a local national in the UAE present with you in the company as a majority shareholder in some activities. So you would really have to think about where you want to incorporate, if you want to fully own, or you don't mind having a local person owning with you the company. The ease of raising funds. So what are the laws in place to raise funds or to reach out for investors? What's the jurisdiction that would be more attractive to investors? Usually in the UAE, you have the DIFC and the ADGM. So the DIFC is Dubai International Financial Center. ADGM is the Abu Dhabi Global Market. And both jurisdictions are common law jurisdiction, and hence they would attract a different type of investor that would be more comfortable in having a common law jurisdiction. That they would rely on when they have a contractual relationship with the businesses they invest in. Another thing to consider as well is the IP protection in jurisdictions. So you would have, in China, the IP laws are not that favorable for the businesses. So you wouldn't want to incorporate your digital tech in China. You would want to incorporate it rather in a country that would respect your IP rights. You should always think as well about industry-specific regulations. All of you are venturing into the medical field and the medical industry, be it on medical advice. Maybe you provide with your digital technology and medical advice, or you would provide a product which is considered as a medical device. And both activities are regulated activities in the UAE. So you cannot just plug and play, incorporate your company and start operating. You should get approvals from the Ministry of Health or from other health departments to register your device or to provide medical advice to customers. One way of doing it is to have your own license that would allow you to do so. Another way of doing it as a startup, if you don't want to go down the route of a regulated activity, is to contract with companies that have a regulated activity in place. So for instance, if you want to provide via your platform a medical advice, you would rely on a company that has a medical advice license up and running, and then they would be providing to the customers, and you would just facilitate this between the company that's providing the medical advice and the customers, but you wouldn't be providing yourself the medical advice. Same goes for medical device. So if you have a company that's already registered in the UAE that can manufacture or market a medical device, you can enter in contract with this company that has all the approvals in place and rely on its trade license rather than to do your own trade license. The third item that you should look at when you define your where is where are your customers. I'll explain in detail. I'll always take the example of Amazon. So Amazon is an e-marketplace that allows you to buy products on the platform. It has this, how do you say, offline aspect and online aspect. The online aspect is the purchase of goods on its platform, and the offline aspect is the delivery of items from its platform to you. The online aspect doesn't require a lot of considerations as to where they want to incorporate in the UAE. They can incorporate in the free zone, they can incorporate in mainland. So this is fine. What they should pay attention more to is the delivery, because they're being offline and they're going to an emirate or to a specific zone where they should deliver to customers. And with this comes the necessity of being incorporated in the zone they're providing delivery services in. Again and again, the same example that we used before, they can either rely on their own license and incorporate in each zone that they should deliver in. So in Dubai, in Sharjah, in Ajman, in Al Quiwan, they should have delivery companies there to be able to operate there. Or they can rely on a company that's already incorporated in Sharjah, that's already incorporated in Fujairah or in Al Quiwan, and rely on its services or on its trade license in order to deliver to customers in these areas. You should also consider that some countries impose the presence of a local entity to collect payment from customers. For instance, I'll give you an example, which is Morocco. Morocco, if you want to have an e-marketplace in Morocco, you should have a local presence in order to be able to collect the payments that the customers makes on the platform. So you should incorporate a company in Morocco in order to operate in Morocco. Even if you're an e-commerce platform, even if you have a payment gateway that's international, money cannot go out of Morocco if you don't have a local presence in Morocco. The final consideration is the data protection laws, the GDPR. If you have, for instance, one of your customers based in Europe or in a jurisdiction that follows the GDPR, your company should follow the GDPR rules and regulations. You should have a data protection officer. You should have processes in place, data sharing agreements with all your suppliers that you share sensitive information with. You should have consent of your customer on processing the data, on collecting the data. So it really depends on where your customer is and what are the legal implications that would follow. The bigger part of our presentation is how you protect your brand, which is the fifth checklist. When we talk about brand, we talk about, obviously, intellectual property. What's an intellectual property? Intellectual property refers to the creation of the mind, including inventions, which can be literary or artistic works, names, symbols, or image used in commerce. It is usually divided into two categories. It's the first category is industrial property, which comprise of patent for inventions, trademarks, industrial designs, and geographical indications. And the copyright, which includes novels, poems, plays, films, music, artistic work, drawing, paintings, photographs, sculptures, architectural design. It also includes the performing artists in their performance, the producers of phonograms in their recordings, and the broadcasters in their radio and television programs. Sorry. So all these items can be protected under the intellectual property. Why is it important for your startup to acquire the IP rights? We talked earlier that you should assign as a co-founder your IPs to the company. One is to guard your patents and copyrights against infringement. The other one is to protect your innovative inventions, to allow you to license your product at premium or to sell your product at premium. Whenever you have a patented product device, you're sure that you won't have a competitor that is selling the same exact device, and then you can price it at a higher rate than if it wasn't considered as patent. You provide exclusive judicial protection of your IP rights. We're going to go into this a bit later. It gives your business a competitive edge in the international market and provides more value for your startup and company when you reach to investors. So the investor would look at the value of the company, and one of the value is its assets. And as a digital tech company or as a startup with an innovative idea, they would look at the intellectual property of your company. And they would measure, they would give value for this, and then they would value your company accordingly. So if you don't have a registered patent for your medical device, they might be interested, but the likelihood of them valuing your product at a very high price, or you're valuing your company at a very high price, is not there. So you should think always of, even if it will incur cost, but on the long run, it will provide you with this valuation that you need for your business. Let's start with the patent. What's a patent? A patent is an exclusive right granted for any new invention or set of procedure resulting from an innovative idea or innovative enhancement to an existing product or imagination that is designed to be implemented on a scientific basis and capable of industrial exploitation or produces value to the user. It can be a device, a product, a process, an application of new method. Yes, so sorry. So what are the laws that governs patent in the UAE? You have law number 44 of 1992. You can have access to it, and it will provide you with what is considered a patent in the UAE, what are the governing authorities that would look at patent, the validity of the patent, etc. So the validity of the patent in the UAE is 20 years. Whenever you register your patent, you're protected against competition for a period of 20 years. Provided, however, that you start, and we're going to look at it later, that you put it in the market. Otherwise, they would oblige you to license your invention, because there is no point of obtaining a patent and keeping it to yourself. It should make, it should be used by the public, or it should be sellable by you, licensed by you, etc. You cannot just have a patent and keep it. What cannot be patented according to UAE law? Obviously, the plants varieties, the animals, the biological ways of producing plants and animals, the methods for diagnosing humans and animals, the special treatment and surgical operations, mathematical and scientific principles, discoveries, and methods, manuals or guides, rules or processes followed to conduct businesses or perform mental activities or play games, and finally, the inventions that may lead to a violation of public morale or peace. The registration procedure, you should provide a clear and concise description of the invention, a technical specification and drawings to support the reason for the application, copy of your articles of association if you're a company, a brief note not exceeding 200 words proving that the invention is inventive and put to industrial use, a power of attorney for your patent agent, a consent letter from the founding inventor in case where a patent is an extension of an earlier approved patent, attested copies of the patent certificate if you have obtained in another jurisdiction a publication, and once approved, the award gets printed, published in the Industrial Property Journal or Gazette of the UAE. What's the process? So the UAE Patent Office would look at three things. It would look at your invention if it's novel, if it's inventive, and if it's of industrial use. They would look at prior arts as well. So they would conduct their own research. The examiner will conduct its own research and will look at similar inventions and would determine if your invention is novel or not. He can reject your application. You can appeal it within 60 days. The accepted patent application will go to the official gazette, which is the official document of that is issued by the government and including all laws that are in place. If there is no objection from any third party within 60 days, your patent is issued. I discussed previously the commercial exploitation of a patent that is mandatory requirement imposed under the law. So if you don't commercially use it, the patent will be subject to compulsory licensing. So a court or a competent authority should force you and to grant a patent license in cases where patent owners have failed to commercially exploit or license the patent. Before we jump into the trademark, I want to give you as well a bit of insight of, based on my experience with patent and the way you should tackle it. The best way to tackle it, if you're aiming that your company will be an international company or your device will be an international device, is to start your patent application in the US and to do an expedite process in the US, get your patent published in the US. Once it's published, start publishing it in other countries. The UAE, the GCC, they have the same process, so you can publish it in all GCC at once. And then you have the EU that has like a patent office. You have other countries. It depends on your expansion plans. But start with the US because it will give you way for your patent to be easily assessed on a later stage. Now we're going to move on to the trademarks. So what's a trademark? Trademarks are designed to protect brands. Is anything by which a customer can identify a product or the source of the product, such as the name associated with the product. Typically, if it is a word, we call it a word mark. Most types of trademarks are either word marks, logos, or slogan. There's a very big common mistake between trade name and trademark. A trade name is what your company is named. It can be anything. A trademark is how you specify your product. It can be the same. Your trade name can be the same of your trademark, but having a trade name in place will not protect you or will not give you the same protection that a trademark registered in the country would give you. This is an example of trademarks. It's a sign. So McDonald's has a sign, Facebook, Twitter, Toyota, Nike has a sign, words, Coca-Cola, eBay, IBM, Google relied on words, letters, HP, LG, BMW, etc., numbers, drawings, and so on and so forth. So the registration procedure of a trademark, it goes more or less the same way that we discussed for the patent, to the exception that if the office, if the trademark office accepted, it should be published in a trademark journal and in 2 local Arabic newspapers. And third parties have 30 days to oppose the publication of the trademark. The registrar will look at it, and if the registrar gives right to these third parties, you can appeal the decision before the courts. A trademark registration takes usually 4 to 5 months. So it's really important as well for you to define as of now, if you're doing all the materials of your medical device, all your materials of your digital technology company under one name, to be sure that you can use this name, at least in the country where you launch your name in. If not in the 5 countries that you're aiming to launch your name in, because you don't want to be faced with a name that you would choose, or a slogan that you would choose, or a symbol that you would choose that is used in the country afterwards, or in the countries that you would want to extend to. So always register your trademark before you go public, if you can. I mean, it entails a cost. I understand that sometimes startups do not have allocated costs for trademarks, but if you can, try to register your trademark before you go public. The registration validity of a trademark is 10 years. It can be renewed for consecutive periods. Renewal time, you have 3 months of a grace period in order to renew your trademark. And that's it. We tackled the opposition of trademarks. The last bit is the copyrights. So copyrights basically are common. They include all the content basically that you provide under your brand. Usually we require them to be registered within the authorities, within the Intellectual Property Protection Department, to be granted the protection for enforcement of these trademarks under the law. There's no requirement for the trademark to be registered, but it would give you a further protection under the law if it's registered. Against third parties, obviously. Unauthorized publication in the UAE of an author work constitute a criminal offense, so it leads to a fine or an imprisonment, and a fine of minimum 50,000 dirhams. So if someone copy your ideas, copy your copyrights, they can face imprisonment or fine up to 50,000 dirhams. Yes, I'm not gonna enter into details of how you can file a lawsuit. That's fine. I mean, it might be important to you or useful to you to know who are the authorities that would deal with trademarks and who are the authorities that would deal with the claims of copyrights. So for the trademarks is the Competition Regulation Committee. You can tackle unfair competition, unreliable advertising arguments. You can go to the Consumer Protection Department because it's harming your consumer basically. You can go to the Trademark Department, and you can go to the Industrial Property Department for trademarks. For the copyrights, you go to the Copyright Department, but if you want to raise a claim against someone who infringed your copyright, you should go before the courts. What's the difference between a protection of a trademark and the copyright? So a trademark certificate will protect you just in the country where you have the trademark published, whereas the copyright certificate registered in the UAE will be protected in 167 countries, the same countries that are part of an international convention called the Berne Convention for the Protection of Literary and Artistic Work. So if you have a copyright, you would be protected in 167 countries by the time you submit it to the authorities here. But if it's a trademark, you should think to register it in each and every country to be protected. Penalties, we talked, so both of them entails, in addition to confiscation of goods, imprisonment, fines, and even deportation from the UAE. I'm gonna tackle the last checklist point, which is the other steps you should consider as a startup. The insurances, and namely the commercial general liability insurance and the professional liability insurance. What's a commercial liability insurance? Commercial general liability insurance are the most general type of policies. It covers you if your employee, for instance, caused damage to property while on the job. Many business owners make the mistake of assuming that commercial general liability covers about everything. That's why it's important to make sure you read your insurance policy. For instance, if you're providing an advice or a professional, if you're a professional providing an advice, or for instance, a lawyer, he doesn't have, the commercial general liability will not protect all his activities. It will protect his premises from employees' acts and omissions, but it will not protect his advice that he would give his clients if it's not accurate, or if it reveals not to be up to the expectation of the clients, or has errors in it, etc. So he would have he would be required to have a professional liability insurance. Other steps to consider, obviously the bank account, and as we mentioned before, you should think about how to repatriate the amounts to your country if you're not resident in the country where your company is incorporated. Corporate structuring of your company. This would come at a later stage. For the time being, you would incorporate just one company as a startup in the country you want to start your business in. But you should think as well, as of now, of separating or making, as you grow, to separate your IP from your operation, from the company that's undertaking the business. The reason being is just to mitigate the risk against your IP, because your IP is your most valuable asset, and you should protect it, you should fence it, you should protect it against any other claim on your business. So if you have a supplier that is not happy with an agreement, you didn't pay, God forbid, someone dues under the agreement, they wouldn't be able to go after your IP. They would go after just the company that contracted with them, which is the business company, not the IP company. So this is on a later stage. In the beginning, you shouldn't pay attention to all these kind of particularities, but you should keep it in your mind that when you expand or when you evolve, you would think about structuring your companies. Tax registration, obviously, and set up basic agreements. When I say basic agreements, you're going to have independent contractors. So you're going to have to sign services agreements. You will have to market for your business, put advertisings on radios, on TVs, billboards, online. So you would have a template. You would like to have your own template of marketing agreements. Obviously, your employment contract you should have a template that would be used across the board with all your employees. Consulting agreements for all your independent contractors as well. You should have certain provisions that are standards and that would apply for everyone. Obviously, if you're a website, I didn't mention it on the slide, but you should draft your terms of use as well, the TNCs of that would be available on the website for everyone who's using their website or the app. And you should draft as well your privacy policies. So it is super important to tell your customers what you're going to do with their data, how you're going to treat it, what you consider as sensitive information, with whom you're sharing this sensitive information as part of your business, who's going to get access, because you would require to have the consent of your customers before you share their information to someone else. That's it for me. Good luck in your startup ideas. If you have any other question, I left my email address. You can reach out to me at any time, and I'll be happy to answer. Naeem, I don't know if you have questions from...
Of course. Thank you so much for the comprehensive presentation. I really enjoyed that you did the comparisons between the popular models and how the legal framework goes in the UAE. I'm sure it's helpful for the participants, especially that the legal aspect is one of the ones that go unnoticed many times. And we actually have a couple of questions. Of course, if you have more, feel free to leave them in the chat and we'll get back to them immediately. Let's start with some of the questions that we received during your presentation. Excuse me. The first question is, which stage should a startup start thinking about the legal contracts? The one you mentioned in the beginning, I guess.
So the legal contract, the founder agreement, I think when they identify their founders, so it's a very early stage. Even if they didn't start, I mean, they should agree with their founder in writing on the way forward and the basics of the relationship as early as possible, because this will really save them time and effort on a later stage when they cannot go back to point zero where they can agree on with the partner.
All right. Okay, moving on to another question. Are there any special laws for medical startups in the UAE?
So it really depends. So there's no one law fits all. So it really depends on the service that this medical startup is having. So if it entails a medical device, as I previously mentioned, it's regulated. If it entails a medical advice, it's equally regulated. If it's just a platform, no. If it uses or it part of the business is manipulating or monitoring sensitive information of patients, of course it's regulated. So it really depends on the startup itself. It really depends on the business of the startup.
All right. Okay, moving on to another question. Should a startup have a legal expert on the team before they have raised funds?
Yes, it's important to protect the startup. It depends when they're raising funds, right? So if they started, they have their MVP, they have their product in place, or they didn't have even so they're raising funds just out of an idea. I mean, the negotiation power will be different, right? So if they have a product in place and in the business, they want to protect it and they want to protect the rights under it. So they would want to have an advice from a legal expert when they start to raise funds. The same will not be happening when they're just relying on an idea that they are pitching it to investors. What I would really recommend is, which is, I mean, starting to be more and more common, but to sign an NDA with whomever they share the idea with. An NDA, which is a non-disclosure agreement, is really important, and a lot of times startups forget about it. If they want to reach out, being to an investor, to a supplier, because especially if it's at an idea stage, they're not protected. So the only way they can protect themselves is via an NDA that is signed with whomever they're sharing their business plan or their idea with.
All right, that's great to know. Also, maybe a follow-up question for me. Would it make a difference if they hire a legal expert on the team or if they go to a legal consultant, like from outside? Does it make a difference for them at any stage? Should there be someone on the team?
Not really. I mean, in the very early stages, unless they can afford a fixed cost of a legal employee, I wouldn't see, I mean, the necessity of having it. They can have ad hoc advice from someone from outside, and then would prepare the basics for them, and then they would go ahead with it. But ultimately, they would really need, when they go public and they start offering and they start having the platform, they start having interactions with the end users, I would recommend to have a legal expert on the team. Yeah.
That's great to know. Moving on to, we have some questions. How should we as a startup highlight our legal plans to the judges? I'm guessing they're talking about the competition, the hackathon we're having. How would you go about highlighting any legal plans in place for a judging panel?
So see, I would assume that the judges would really appreciate the fact that the founders have already agreed on a lot of stuff together. So if they highlight what's the responsibilities of each one of them in the startup, if they present themselves as people in agreement, that would give them more credibility in front of the judges. So to agree on the basics, to mirror this to the judges would have a value. I think so. Yeah.
All right. And I'm guessing this is our final question. Does having a legal plan affect fundraising?
Well, it depends what's your definition of legal plan, right? So it doesn't. It depends on the fundraising type that you're looking at. If it's angel investors, friends and family, they wouldn't really care about your legal plan. But if it's an institutional investor, he would look into your company's detailed and incorporation documents. He would undertake a due diligence. I mean, the more value an investor would put in, the more money an investor would put in the company, the more requirements he would ask for. So yes, I would say it really depends on the nature of the fundraising and what they mean by legal plan. But the basics should be here. So I would assume, I mean, they should incorporate a company, and this company would go for fundraising. If they're still in an idea stage, the fundraiser might help them in the incorporation process. So it really depends on where they are, at which stage of the startup they are in. I think there's a question in the chat room. If a health tech company opens its office in a free zone, can it extend its operations across UAE? That's a really good question, and it really depends as well, as I previously said, on the offerings of this platform. So if it requires services to be done offline, then yes, it cannot extend its operation across UAE unless it has presences in other Emirates. If it's just an online platform, then it's fine. I mean, as long as it remains an online platform, then that's fine.
All right, and with that, I'm not seeing any more questions. With that, I think we'll conclude our workshop. I just want to thank you again, Ghassan Haddad. Thank you so much. It's been a pleasure to have you with us, and thank you for the great presentation. I'm sure many of our startups found it helpful, and we'll conclude with this. Thank you so much.
Thank you. Thank you.
Thank you, everyone, for tuning in, and we'll see you in our next workshop. Have a good day.